Okay, hopefully this is the last time I have to do this. LB 227 is on, I believe it's final reading. There's been a series of amendments, and this final amendment is the one that I'm sort of explaining, and the thing that you can look at to sort of decide if you want to support this or not. Remember, we had these two farmers on row crop operations, the Smiths and the Joneses. The Joneses was, I think it was 1985 for the Smith, 1987 for the Joneses. Smith in 1990 puts in a feeding operation. The feeding operation at that time is not a nuisance, even after it's up and running. And the reason is because it just doesn't substantially interfere with Jones's use of the property, even his household use. So we don't have any liability involved here. The right to farm law, in fact, isn't even in play because there is no nuisance that exists as of 1990. In 2000, I believe it was, we have the Hansons move in. They buy a 20-acre tract from the Joneses. They put a house up next to the feeding operation, and that is sort of the thing that the right to farm law is geared at protecting the Smiths from nuisance liability that arises because of a change in the neighborhood, specifically a change to a residential use or a change in the occupancy of the use. But in other words, there's something that comes after the established operation that makes things nuisance-like. And the nuisance standard, it doesn't necessarily care who was there first. That's one factor to consider, but it's not the only factor to consider. Nuisance standards are pretty broad. So what happens with the right to farm law is we sort of codify this notion of coming to the nuisance, and we protect the Smiths from the Hanson lawsuit. Okay? All of that exists now as a right to farm law, and 227 doesn't change any of that. It continues that. But we have this subsequent change that we've been dealing with, and specifically it's this hog operation. And under one version of the facts, the Joneses sell another 20-acre parcel to Smithfield in, let's say, 2019. Smithfield puts in the swine feeding operation, or maybe it's a subsidiary of Smithfield, or maybe it's some other farmer, or maybe it's Jones himself. At the end of the day, this new operation comes in next to these existing residential homeowners and the existing agricultural user, Smith. You've got a new neighbor in the neighborhood. In the hog operation, under our facts, it becomes a nuisance, right? It substantially interferes with the use and enjoyment of the Hansons' residential property, and maybe even the Smiths' livestock operation, because maybe they're doing, who knows, something that's sensitive to something that swine attracts, like, cats or starlings, or who knows. But in any event, we've got at least a viable claim by the Smiths, the Hansons, maybe even the Jones, if they retain property, against Smithfield. Because Smithfield was their second, it doesn't get nuisance protection under the right to farm law, right? That's just the way that this thing works. But under LB 227, as it's been changed, Smithfield will get nuisance protection. Specifically, it will get nuisance protection after 2 years have elapsed between the time that the Smithfield operation becomes a nuisance and the time that the plaintiff sues. In other words, if the plaintiff waits too long, it can't be held liable. Smithfield can't be held liable in nuisance for its actions. Now, we're assuming that Smithfield's a nuisance, and we're also assuming that the clock has started to run. This is one of the difficult things with the way that they're doing this particular statute. That clock begins to run when the nuisance exists. That's when the plaintiff knows, or perhaps should know, that it has a viable claim for nuisance. The difficulty in that notion, the difficulty with this question of when we should start the clock to run, is that nuisance liability isn't that clear, because again, we're balancing the rights of adjacent landowners. The Smiths versus the Joneses, the Smiths versus the Hansons versus Smithfield, Smithfield versus Smith. We're trying to figure out who should have to remediate, or who should have to adjust their operations in order to accommodate other people, and that's a very difficult question. The best that we've been able to come up with over hundreds of years, or 150 years of the common law of dealing with this particular problem, is to say, well, use your land reasonably. Do unto others as they would do unto you, or as you would have them do unto you. The whole idea is basically to avoid unreasonable interference. We have to balance the social utility of one use versus the burden that's imposed on the harmed party, and we have to, do that in a court. We have to basically go to a jury and ask them who should win. So all of that's very difficult to pin down. This bill seems to assume that there's a particular point in time when a nuisance will definitely exist. And at that point in time, the clock starts to run, and you have 2 years from that point in time in order to file your lawsuit. And if you don't, it does not matter if you are a nuisance. That is, even if you are a nuisance, you get the defense. This insulates nuisances from liability so long as 2 years have passed from the time that clock started to run. And when's that clock start to run? Who really knows? So that's the difficulty with this legislation. It doesn't require that Smithfield be in compliance with zoning. It doesn't require that Smithfield be in compliance with any sort of Clean Water Act permitting or any other regulation. It simply says as long as Smithfield has been there for 2 years, and you should have known that you should have sued them within that 2 years, regardless of whether you could have sued them or not. Like if you had the money to hire a lawyer or any of that, Smithfield is going to win in all of those cases. And these landowners, these adjacent landowners, will have to bear that burden. So the difficulties I see, one is when does that clock start to run? Two, if you can't hire a lawyer because you don't have the money to hire a lawyer and it takes you 2 years to get around to doing it or to come up with the money to do it, it doesn't matter. You're out of luck. You won't be able to make out this lawsuit. And then finally, this question of when that clock begins to run, that's going to require or add an additional layer to the litigation that will ensue. That further increases your costs as a plaintiff and further makes it more difficult to hire an attorney because it's going to cost more to hire that attorney. And even if you can find an attorney on a contingency fee basis, that attorney is going to look at the case and say there are a lot of things here to litigate and the recovery just doesn't quite justify taking that chance. Because remember, there's no punitive damages in Nebraska or anything along those lines. So very, very difficult for these neighbors to be able to sue. If this passes, and I don't know if it will, but if this does pass, then neighbors need to know if a new hog operation or a new chicken operation or any new operation comes in, or if anything changes next door, the moment you think that you would be able to make out a claim, you need to file a lawsuit. You need to get something in the hopper because you've only got 2 years to make that filing. And you run the risk that the clock started before you really knew it had started. So that's the difficulty I see with this. I don't think it's the best policy in the world. I don't know what exactly it accommodates on the agricultural side. I mean, after all it does is protect new operations from nuisance liability in situations when they are nuisances. That is all that this does. And the Smithfields of the world and other folks are going to reap the benefits of that in situations like this. So that's basically what we're looking at now. It's on final reading. It's probably got the votes to pass. The main opponent to this legislation introduced this change. So it'll be interesting to see what happens. If it does, I mean, not all is lost, but it will require some vigilance on the part of landowners to really get their lawsuits going and really to be wary about losing those sorts of things. Thank you.